Your Honor, counsel, ladies and gentlemen of the jury. First off, let me again thank you so much. I want to echo what Mr. Murphy said in his opening statement as well as what I had said earlier. Our system doesn't work without your service. I looked over. I know you were paying close attention to all the evidence and all the testimony. We appreciate that. This is an important case to everyone sitting in the courtroom today. And your attention to these matters is key in what happens. So no matter what you decide, I want you to know that as a community, we thank you for your service. Now, usually when I start my closing statement, I'll focus on the burden of proof instruction. Because nobody wants an innocent person to be convicted. We all want people who have committed crimes to be those who are convicted. So certainly, I bear the burden of proof. And if I have not proven to you beyond a reasonable doubt that the defendant has committed these 3 acts, you must find the defendant not guilty. Oftentimes, I will go into what is a reasonable doubt. It's not all doubt. It's not beyond all doubt. It's reasonable doubt. And sometimes I'll use an example. But you know what? You're about to make your decision and go back and discuss this. I don't think that's even going to come into play. I think this is a very easy decision for you to make on all 3 counts. The evidence was uncontroverted. You got to see various angles. I have the video up. We'll play it in just a moment, one of them. But you got to see various different angles of exactly what happened. You know better than anybody what happened in this case. And there was no evidence presented that contradicted what the state showed you, that it was anyone but the defendant who committed these actions. Now, it's football season, but I'm looking forward to summer, and I'm a baseball fan. So oftentimes, I look at the jury instructions kind of like scoring a run in a baseball game. You don't score a run unless you touch every base. Well, you can't convict if I haven't met every element. So let's look at the elements of these specific instructions that you will have back with you. This is the law that we talked about the judge being able to instruct you upon, and we've already given you the evidence upon which you need to apply. Let's look first at burglary. The defendant intentionally entered a building. Let me hit play. I don't really have to argue much about that. If you look at the video, and if you look at the door, and just for the record, I'm at 7:32 on the Windows Media Player, 9:37 and 35 seconds on the clock. And if you look in this section, you've seen he's already hit the door. The dust is falling from the ceiling. You see the window shake as he's broken through. Now, you can't see the arm in this section, but you can in another. Couldn't get in. So there's more hammering away at the door. We see him do a dive roll. We see him flip a hammer. With a bag in his hand, the first thing he does is grab movable property. That being firearms. We don't stop with one. We pull and yank and destroy another cable by pulling another one off the wall. That's not enough, so let's grab a third and pull another long gun. Remembering that one of those is an automatic weapon, a machine gun type weapon. Now let's go and grab some guns. Here's some handguns. 2 of those end up having silencers on them. The defendant is pulling more and more. One side wasn't enough, let's go to the other. And load up. You can see the bag next to the chair. You see so many guns that a couple tumble out. You see ammunition thrown in the bag, grabbed in his hands and put in the bag. See him now go and grab the magazines. Go to the wall. Look at them. Which ones do I need? Well, let me grab these. Take a moment. Run back to his bag. And dump more magazines into his bag. Well, we'll go back to the same wall. We'll get some more parts and more magazines. Run back and put them back in the bag. Let's grab some magazines and other gun parts from this wall. Put them in the bag. Went once, why not twice? Put them in the bag. Make sure I can fit everything in there. Wow, it's full. See him zip it up? Lift it up, little difficult, it's so heavy, and out the door we go. And look at the shambles that that gun shop is now in. Not nearly what it was when he entered the store. And look what's sitting on the floor. There's a hammer. We'll get to that in a moment. Did the defendant intentionally enter a building? It's clear. You saw him pounding away at that front door with a hammer in his hand and a bag that he carried there. He didn't just find them on the ground. He planned it out ahead of time. And how do we know he planned it out ahead of time? He took the time not only to have that hammer in his hand when he went, and that bag, and what was the bag for? To put stuff in. But he also wrote an apology letter before he even did this. So he thought it out. You saw the crime right there. The crimes, plural. So let's go back to the elements. The defendant entered the building without the consent of the person in lawful possession. You heard Mr. Cool specifically tell you yesterday, I didn't give him permission. I didn't give him permission to go in the store. I didn't give him permission to take my stuff. I didn't give him permission. Those are easily met. The third, that the defendant knew the entry was out without consent. The facts show that. If you have consent to go into a building, what do? You open the door and you walk in the building. When you don't have consent, you grab a hammer and beat on the window. You do a dive roll in, you cut your hand. You leave your DNA behind as you're coming around and touching a stool. It's clear from the facts. Certainly, we can't look into Mr. Jakubowski's mind. And we can't see, oh, that's where his consent is. But the facts show that. The facts show that he knew he did not have consent. And the defendant entered the building with the intent to steal. That's certainly clear as well. Why did he bring a hammer? Why did he bring a bag? And why did he go there when the shop was closed? It's easily shown by the facts of this case. And it's uncontroverted by any of the evidence that that's what he did. Burglary is extremely easy for you. But you don't stop just at the burglary instruction. There's a second instruction that you'll have. And I've marked a couple on it just because the others have numbers. It's easier to point out. You then, once you decide that there's been a burglary, have to decide if he armed himself with a dangerous weapon. And the question you're going to be asked is, did the defendant arm himself with a dangerous weapon while in the enclosure? And the law goes farther to help define for you so you don't have to do what lawyers often do. We parse syllables too much. What is. A dangerous weapon means an item that can inflict death or great bodily injury. I asked Mr. Cool yesterday, would all of those weapons, if used on a person, kill them? His answer, yes. Your common sense, and that's another instruction, which I love that we include that in the state of Wisconsin. You get to bring your common sense to the courtroom. You don't leave that behind. You leave behind your notions, but you don't leave behind your common sense. We all know what guns are used for. Hunters know that they're providing for their family by killing a deer. We all know that if that same gun is turned on a human being, that it'll cause the same death. We know what a dangerous weapon is. We go farther, and it defines for you what armed means. Armed means the defendant knowingly took physical control of a dangerous weapon. You saw on that video, you see the empty spots now as I've paused it, where he went up to that video, grabbed that long gun, that machine gun, yanked it off of there. It wasn't an accident it fell in the bag. It was Mr. Jakubowski using his hands to rip it from the wall and put it in his bag. He knew he was taking physical control of a dangerous weapon. And the enclosure issue is as proven by that video as anything else. We know that he went into a building. He went into the gun shop to steal that weapon. And when I say weapon, it was 18 of them. Not one, not two, 18 weapons. Now we look at theft. Again, we lay out for you in the law exactly what you need to look at, the elements that I have to approve it. And again, if I didn't prove them, you must find him not guilty. But the evidence was clear. It was uncontroverted. I might even go to say it's beyond all doubt. There's no reasonable doubt. It's even farther than that. This is that clear cut. The defendant intentionally took and carried away movable property of another. You heard the testimony from Mr. Cool. That was his property. He is a business owner in Rock County. He's there to provide for his family. He owned those weapons. His shop owned those weapons. And the defendant went in and took them. They weren't the defendant's, but he took them. It's clear that the defendant intentionally took and carried away property of another. The second element is the owner of the property did not consent to the taking and carrying away of the property. It was clear. Mr. Cool said, I never gave him permission. Uncontroverted. You didn't hear anything about permission given. No, what you heard was Mr. Cool said, I never gave him permission to take those items from my shop. The defendant knew he did not have consent. It's pretty clear when you have weapons that are chained or locked to the wall and you rip them out, breaking the chains, you don't have consent. Common sense tells us it's clear from everything we've seen, the defendant did not have consent. And then finally, 4, the defendant intended to deprive the owner permanently of possession of the property. Boy, is that clear. The defendant never returned any of the weapons. 5 guns and 1 silencer were found with him in Richland County. And I asked the question of Detective Bentley. Were there any other guns found? No, they've never been returned. The facts and circumstances are clear. The defendant did not intend to return those weapons. The defendant took those weapons. And you know what? He wrote a letter saying, yeah, I'm taking these from you. I'm sorry I'm doing it. He never intended to give them back. The third count is burglarious tools. Again, very straightforward. The defendant had possession of a tool or a device. If you look at that video on the floor, what do you see? You see a tool or a device. It happens to be the same one that's Exhibit 6. The defendant went into the store with this hammer. You can see the black handle, the Stanley black handle right there. You can see the metal on top. You see the metal on top. This was collected at the shop. You saw the video of the defendant walking with it in his right hand with a bag in his left coming around the building. Before he was in, he walked up alongside the building, he turned the corner and came to the front. And what did you see then? The defendant taking this hammer with his shoulder towards the door and the bag here and pounding and pounding and pounding away at that door. Reaching in, trying to unlock the door. And when he found that the deadbolt needed a key, what did he do? He broke the rest of the window. And he took a dive in and flipped the hammer. And it stayed on the floor in that location until police took it into evidence. And you heard about how that was done and put it in this box. And it was unsealed for the first time since that night yesterday. Did he have a tool or device? You've seen the tool. You've seen it in the video. You've seen it behind me. You've seen it when it was shown to you by the bailiff. Of course he had a tool. The tool or device was suitable for breaking into a building. Well, yeah. You saw it happen. He took that tool. It was suitable to break a window. And guess what he did with it? He broke a window. It doesn't have to be some special tool. It says that. It may include common tools. Tools that we would have in our workbenches at home. Like that hammer. And 3, the defendant intended to use the tool or device to break into the building with intent to steal. How clear is that? Do I really need to say any more about that? I'm a lawyer, so of course I will. But it's so clear from the video. He intended to use it. It didn't magically fly up and break the window itself. He was pounding on the window. And did he intend to steal from the shop? We've already gone over that. That's clear. Off the wall, into the bag. Off another wall, into a bag. From a gun counter, into the bag. It's clear. It is clear. The video alone is clear. Now, some may say, and I disagree, that first video where he was pounding away and looked straight at the camera, I think you can look at that and say, yep, that's the defendant. But you know who says that's the defendant? The defendant. Remember, the defendant in another court proceeding was asked about that. The defendant was asked. Remember we went through this transcript? And I went with the questions, and the officer acted as Mr. Jakubowski giving the answers. Mr. Jakubowski, do you remember where you were on April 4th of this year? I do. Can you please tell the ladies and gentlemen of the jury what happened on that day? I broke in, I robbed Armageddon Supplies. Okay. What did you take when you robbed Armageddon Supplies? Guns, magazines, bullets. The defendant tells you he was in that shop. And he's the one who committed this burglary. But you know what else tells you? Science. Science. I showed this angle because I think it gives you the best view of what he did. But if you notice, right by the door that's now open, you see the stainless steel stool. And you saw him, when he came around because he had stuff on the ground, use it for balance. Remember, he used it for balance as he came around to get stuff off the wall, to get the parts, to get the magazines. And what was collected from that? You heard testimony. Blood. 3 swabbings of blood by the Rock County Sheriff's Office at the direction of Detective Bentley. They took the blood and they transported it to the Wisconsin State Crime Laboratory and hit the jackpot with the person who did the testing. That was a phenomenal, experienced individual. From college when he worked with CODIS, all the way up until present day. An expert who has testified in Florida, in federal court, in Wisconsin, in Illinois, in California, all across the nation. If you remember, I went through all those states, and that was only to 2009. I didn't even bother going any farther than that. We have an extremely experienced DNA analyst whose goal is not to convict anybody. He told you that. His goal is to show you what the science says, good, bad, or indifferent. He'll testify for the defense, he'll testify for the state. It never changes what the testimony is. The testimony is science. And what he explained to you about DNA testing is that each of us has our own DNA signature, if you will. My word's not his, but I will break it down a little bit. That everyone has their own unique DNA. And yeah, we can fluff off cells when we touch things. It's very uncommon. You're not going to find it. Heck, the lab won't even test most of the time for those kind of things. But biological specimens, they'll test. And I asked, okay, so what's a biological specimen? Blood, urine, saliva, our fluids. So he was asked, you got this blood sample from the Rock County Sheriff's Office. And what did you do with it? Well, we tested it. I found that each of the 3 different specimens was the same individual. And remember, well, maybe, kind of, could there have been, maybe, kind of, someone underneath that? Could be. I'm never going to say never to everything. But what I am going to say is that 1,000 times the population of the Earth, he's the guy. That means the Earth would need another 1,000 people, and there would still be no one else on this earth that would have his DNA. It was him. And you know what we did? We tested against a data bank. We threw it out there. We didn't know who it was. I didn't know anything about the burning of the vehicle. I haven't even talked about that. So we put it into the data bank. And what did we find from the data bank? We got a hit. And he didn't say, oh, that's absolutely what it is. He said it was an investigative lead. That they refer to law enforcement to keep investigating. That's not, okay, here we go, woo-hoo. So when the defendant is found and a buccal swab is used, a buccal sample, and we've had it explained by a couple people. It's a Q-tip on a longer stick. They put it in the mouth, they circle it, they get the skin cells from inside your mouth. When a buccal swab is collected from the defendant, it was again tested against the specimen. It was typed. We type this one, we type this one, and then we compare scientifically, and what do we find? It's the defendant who was in there. So now not only do we have the defendant telling you that he was in there, we have science telling you he was in there. And we also have Mr. Cool telling you he was in there. Because Mr. Cool recognized him from when he went to the shop previously. And when he watched the video, he goes, that's that guy who was in my shop previously. And the defendant himself confirms that when he tells Detective Bentley, yeah, I went there twice before that. Before the burglary, I was in that shop twice. I knew exactly where things were. I had been in the shop. And yeah, I took the stuff. So from the defendant's own mouth, you have the admission in an apology letter. I guess that would be more of his hand. From his mouth, you have the admission to Detective Bentley when he gave a statement about exactly what happened. And from the defendant's own mouth, twice in court, not just the information I just read to you, but at another appearance in court, he informed the court, I did it, I took the guns, and he's not getting them back. Ladies and gentlemen of the jury, when I said to you, I don't really need to get into the whole what is reasonable doubt situation, it's because there is no reasonable doubt. Frankly, there's no doubt at all. I will agree with Mr. Murphy on one thing that he said in his opening statement. When he said, this is a robbery while arming himself case. Absolutely. This is a case that the evidence is so clear. Not only is it clear, it's uncontroverted. There's no evidence that say maybe it was something else. And the evidence itself is so clear on exactly what happened. On April 4th of 2017, the defendant chose to go to Armageddon Supplies. He chose to pick up a hammer. He chose to take a bag. He chose to steal after he committed a burglary. And what did he choose to steal? Guns. Fully automatic, semi-automatic, and handguns. That was his choice. And we heard a red herring a little bit. Well, he didn't even match the bullets to the gun, and that's not what the instruction says, is it? The instructions are very clear when you go through them. Now, one of the instructions defines a firearm a little different. It says basically using gunpowder to fire. I asked that specific question of Detective Bentley. And he said, yes, that's what these are. These are fully functioning firearms. You don't have to prove that he matched bullets or didn't match bullets. You just have to prove he took the firearms. Frankly, he took guns that were 22s. He took bullets that were 22s. We know that he did match in some of the firearms. But all of the other stuff is just the old magician's trick. Look over here when the real thing is over here. Don't fall for the magician's trick. Use your common sense. Apply the evidence to the law. And I'm sure that when you apply the evidence to the law, you will find the defendant, Joseph Jakubowski, guilty of burglary while arming himself, guilty of theft of a firearm, and guilty of burglarious tools. Thank you very much.